and those are the legislative preferred measures. There are 6 constitutional amendments that are proposed by the legislature that will be on the ballot, starting with Proposition 133, which is relating to primary elections. You will also see Proposition 134, which is relating to initiatives and referenda. Proposition 135 is relating to the governor.
Washington came and they did have a copy of the proposition.
Oh yes, we definitely provided. Right now, the publicity pamphlets are being printed and they're going to be placed in the mail shortly. And so typically during the town halls, we do provide publicity pamphlets, but we didn't have those today, but we did print out copies of the ballot language, which is the yes and no language that will appear on the ballot. And we have someone who's passing that information out now.
Can you tell us who you are and your position?
Yes. Yes, my name is Renata Fisher. I'm the Deputy State Election Director for the Secretary of State's office. The Deputy State Election Director. No, our next town hall will be next weekend in Tucson, and then the one after that will be in Phoenix. Okay. Proposition 135 will also appear on the ballot, which is relating to the governor. Then we have Proposition 136, relating to ballot measures. Proposition 137 will be relating to the judicial department. And Proposition 138 relating to wages. There were also 5 statutory measures that were referred by the legislature as well, which is Proposition 311, relating to first responders, Proposition 312, relating to property tax, Proposition 313, relating to child sex trafficking, Proposition 314, relating to responses to harms related to an unsecured border, and Proposition 315, relating to rulemaking. No, because I was going over the propositions that we wouldn't be discussing today, and those are the ones that were referred by the legislature. No, you're welcome. Now, the ballot measures proposed by the Citizens Initiative petition. There were 2 constitutional amendments that are proposed by initiative petition. Proposition 139, which is the Abortion Access Act, and Proposition 140. Make Elections Fair Arizona Act. Now we will begin the discussion regarding Proposition 139, the Arizona Abortion Access Act. After I provide the overview of the act, I will then turn it over to the speaker for 139. After that, I will then open it up for comments or questions regarding Proposition 139. After that, then we will, after we finish the discussion regarding Proposition 139, we will then continue with Proposition 140 in that same order. So Proposition 139 is a proposed amendment relating to the fundamental right to an abortion. Within the title and text of that proposed measure, it states every individual has a fundamental right to an abortion. Within the title and text, it states the state shall not enact, adopt, or enforce any law, regulation, policy that does any of the following. So the state shall not deny, restrict, or interfere with that right before fetal viability, unless justified by a compelling state interest achieved by the least restrictive means. The state shall not deny, restrict, or interfere with an abortion after fetal viability. That in the good faith judgment of a treating healthcare professional is necessary to protect the life, physical, mental health of the pregnant individual. The state shall not penalize any individual or entity for aiding or assisting a pregnant individual in exercising the individual's right to an abortion. There were two definitions provided within the text of the measure that was proposed. I'm going to define those for you. A compelling state interest. Enacted, adopted for a limited purpose of improving or maintaining the health of the individual seeking abortion care, which is consistent with accepted clinical standards of practice and evidence-based medicine. Does not infringe on that individual's autonomous decision-making. The measure goes on to define fetal viability. The point in pregnancy when in good faith judgment of a treating healthcare professional, and based on the particular facts of the case, there is significant likelihood of the fetus's sustained survival outside of the uterus without the application of extraordinary medical measures. As you have the information in front of you, on the ballot, a yes vote for Proposition 139 would indicate shall have the effect of creating a fundamental right to an abortion under Arizona's Constitution. The state will not be able to interfere with its fundamental right before fetal viability unless it has a compelling reason and does so in the least restrictive way possible. Fetal viability means the point of the pregnancy when in the good faith judgment of a treating healthcare professional, the fetus has a significant likelihood of survival outside of the uterus. Throughout the pregnancy, both before and after fetal viability, the state will not be able to interfere with the good faith judgment of a treating healthcare professional that an abortion is necessary to protect the life or health of the pregnant individual. The state will not be able to penalize any person for aiding or assisting the pregnant individual in exercising the right to an abortion. On your ballot, a no vote for Proposition 139 means shall have the effect of not creating a fundamental right to have an abortion under Arizona's Constitution, will leave in place current laws that restrict abortion before fetal viability, and will allow the state to further restrict or ban abortion in the future. At this time, I will ask the opponent for Proposition 139 to speak, because we do not have an official representative from the committee to speak for proposition in favor of Proposition 139. So at this time, I will turn it over to Ms. Jill Norman.
Thank you for having us, Secretary of State, down here. I really appreciate the opportunity to talk against Prop 139 and what the language really means. This is the third time that the proponents of 139 have not showed up to debate. They missed a clean elections debate, they missed the Horizons debate, and now again, this town hall debate. Why do they not want to debate us? Why? Is it because we're going to call them out for the lies that this campaign has been talking about? Prop 139, abortion is legal in Arizona up to 15 weeks. What Prop 139 does is eliminates the care of the doctor. People talk about the doctor-patient relationship and that the abortion should be a decision between the doctor and the woman. Prop 139 eliminates a qualified medical professional from performing an abortion. That is extremely risky for women. Now you're taking them in a procedure that has current safeguards, and you're turning that over to people who have no subject matter expert of that procedure, literally approving substandard care for women. What this initiative also does eliminates parental consent for minors. If you have a minor that is sex trafficked, God forbid, or has been raped, that minor literally could go to school, somebody could pick her up, her predator, trafficker could take her to abortion, and the parents have no idea. They would not even know. Again, this is not protecting women. This is not in the best interest of girls and women. Also, 60% of abortions now are by the abortion pill. What this does is makes mail-in abortions legal. Mail-in pills, legal. Anyone can order them at any time. So what could happen is a child could get an abortion pill at school from a friend, take a pill, literally hemorrhage in the bathroom, have no idea, no oversight from a medical professional, and 25%, 1 out of 25, end up with complications in the hospital. Again, extremely risky for women. This literally is a modern-day back alley abortion. Prop 139 takes away the safeguards that we have currently in place. We have abortion up to 15 weeks now by a medical, qualified professional. Someone whose scope of practice is to do this abortion within hospital care, hospital standards, and with hospital privileges. This takes that away. Abortion is not health care. It is not health care. And we're here to set the record straight. And again, no proponents of 139 are here yet again today. The third time they have refused to answer. Their language in the proposition is extremely vague. They talk about it's only up until fetal viability. Their attorney, Austin Yost, clearly says in the Superior Court, this initiative is before and after fetal viability, clearly stated in court. I want people to be able to understand, be educated on this initiative, and then decide what's in the best interest of women. And I'm here to tell you that opposition to Proposition 139 is in the best interest of women.
Thank you. Are there any public comments?
Yes, I'd just like to sort of add to what was said. There certainly are a number of things that are in this proposition that are very disturbing. As noted, the language is very ambiguous. Basically, it stipulates that the language of the proposition should be interpreted in the most liberal means possible with regard to affirming the right of abortion. It does put into risk a lot of common sense procedure, things such as parental consent. It certainly would put that in jeopardy. All this stuff depends on how courts rules, but the way the proposition is written is to push courts into eliminating any possible restrictions on abortions, which could include parental consent. Your daughter could become pregnant by whatever means and have an abortion without your knowledge. And also would open the door for people to take a girl or a woman to have an abortion who could have been abused by that person, who could have been involved in sex trafficking by that person. It also puts in jeopardy a waiting period, ultrasound prior to the abortion. Certainly abortion can have adverse effects on women. In fact, there is a wealth of literature that shows that women post-abortion, as compared to women who delivered, have increased risk overall of mental problems, also at risk for death from suicide, violence. It seems to be that having an abortion maintains a woman in a situation which has risk to her health, whereas giving birth does not. And of course, there is the unborn child. We haven't heard about that. But there is another human being involved in the decision of an abortion. The unborn child develops by the time 8 weeks post-conception. All the organs are in place, all the limbs, fingers, and toes are there. They are not fully developed, but they are there. The proposition, as stated, opens puts these unborn children at risk. About 60% are done by medication, which the baby is killed by injecting, giving a medicine which counteracts the effects of progesterone, which are necessary to maintain the pregnancy. The baby dies, and then is expelled. There's about 30%, 35% of abortions done surgically, in which the baby is torn apart, the limbs are removed, the torso is macerated, the skull is crushed, the brains are sucked out. Not a pretty procedure. That is what this proposal is going to sanctify in our Arizona Constitution. And what I find most troubling about this is it allows for abortion after viability. Once the baby is viable, and a woman does have a legitimate need to terminate the pregnancy, the appropriate measure is to deliver the baby alive. You don't have to kill it first. You don't have to dismember it. But the abortion mentality which is behind this amendment cannot even recognize the unborn child as being a human being and offer compassion, even when it can live outside the home. So these are the things that I find most disturbing about this proposition.
Thank you, sir. Are there any other comments? We want to make sure that the comments are limited to approximately 1 minute, because we want to make sure that everyone has an ability to speak and would like to speak. So we want to make sure that we limit comments to 1 minute or less. I think if so, this lady stands first, and then you're next, sir.
Am I allowed to ask a question at this point, or only make a comment?
Let's do comments first, and then do questions afterwards. Do you have a question or comment? Okay. Are there any other comments?
Well, I just wanted to, if someone from the Secretary's office could explain to us the procedure of how the opponent is, the proponent of the bill is invited and how they declined, just so I can kind of understand where this fell apart.
What happens is, for example, I personally sent out the invite by email, inviting the proponents as well as the official opposing group the opportunity to speak 4 minutes each, and then of course I received responses back stating with the decline. And so
they declined, and that was an invitation to sit on the panel, is that correct? To be part of the panel?
well, yes, to speak for the measure.
My biggest problem, because I think everybody, including the proponent, has spoken to the issues of human trafficking victims being absolutely victimized by the availability of the abortion pill and no oversight. And I want to make sure two comments. One, we're learning more and more that particular medication is extremely dangerous to women, as you said. There are 2 recent cases of a woman with an ectopic pregnancy and a woman with twins who both died after receiving the abortion pill because they were not under a doctor's care. There was no ultrasound done to determine the nature of the pregnancy, and both of those women died. So having no interference with abortion, etc., it kind of overturns and wipes out any protections under Arizona law. My biggest problem with this is it says it relates to a fundamental right to abortion. That is incredibly dangerous language for conscience rights, for medical concerns, for anything. We should not put into the Arizona Constitution that there's a fundamental right to kill unborn children or a fundamental right to an abortion that fundamentally other people's conscience rights are diametrically opposed to. Saying there's a fundamental right to abortion is extremely dangerous language.
Thank you for your comment.
Just a brief comment. Once you open the doors to the legality of killing babies, you're actually having death for anyone or the other person. When they talk about elderly, they don't like it, blue eyes and blue eyes. You know, it's ridiculous that anyone would suddenly want to open the doors to kill babies.
I would like to make a comment, and that is, when you think about it being a fundamental place, better safeguards for women, for children. Anything can happen going forward if Prop 139 passes. So we could have these modern day back alley abortions, these young girls and women dumped in the emergency rooms, 1 in 25, we know are being, have severe complications with bleeding and other things like that in the ER. So let's say we, us as citizens, wanted to talk to our legislatures and say, we want a new law about this, about medical abortion or about minors not being able to get the abortion bill. Whatever we wanted to ask our legislators to bring in a new law, that could not happen under Prop 139 because it would be a guaranteed fundamental right. So we, as Arizona citizens, couldn't even go to the democratic process that we are supposed to be given as Arizona citizens and legislate anything because of this amendment and fundamental right. So I feel that it is a complete attack on my right as a person in the state to be able to do anything in the future. And the other big issue that I'm really upset about too is that this strips away everything currently on the books. The ultrasound that we have for women today before an abortion is there for care. It's there to identify, does the woman have an ectopic pregnancy? Why is that so important? Because we know that 2% of women do have ectopic pregnancies, and if that's not detected, they can die from an abortion. We know that by the facts with the CDC. And then also, if we don't know how many weeks of pregnancy a woman is, and she's given the abortion pill too late in her pregnancy, that can result in death. Exactly what happened to this poor Georgia woman that tragically died from the abortion pill. She should have never been given that abortion pill. So that was completely botched by the abortion industry. She was not treated correctly, and she should not have been given that abortion pill. And she wasn't even treated by a doctor or given an ultrasound, and she had twins. So here we are, and if this gets into the Constitution, we have no ability to regulate, legislate, anything. So those are some of my concerns as an Arizona citizen.
Thank you. Comment or question? Just comment or question. Let me give it to someone else.
Absolutely.
Was the individual that wrote this a fool, or were they evil? Read how this is written. I see no space, zero space whatsoever. Either they were a fool, or they were evil. Why do I say that? Ambiguity is not your friend. And that is no more true anyplace else than putting it in our state's constitution. When the famous case Roe versus Wade was held by the Supreme Court, they made up all this terminology. Trimesters, woman's right to choose, found in the Constitution. But they included the weaponizable ambiguity of the health of the mother. People thought for decades after that Roe versus Wade allowed abortion in the first trimester. But the immediate subsequent Doe versus Bolton said, well, a woman can just get in there and have an abortion for any reason. She can have her arm twisted by her handler, by her master, by her sexual slave master, and that's okay. So whoever wrote in this initiative, viability, they're either an idiot or they're evil. Did you hear what the attorney for this said? This would enshrine abortion to the nanosecond, to the moment of birth, of live birth, in the state's constitution. Abortion, in other words, it has nothing to do with viability. That's intentional, duplicitous ambiguity. They're either an idiot or they're evil. Either way, I hope everyone rejects that. It is working against us. Thank you.
Thank you.
You said Doe versus Bolton is still on the books. It was put out the same day as Roe. It's still on the books. And no one's even talking about this thing. It basically said health is basically anything you want it to be. It can be familial, whatever that means. It can be, you can have a psychiatrist saying you can't handle this, you can have an abortion. You can say, potentially, it doesn't say what can't be done. But it says, I just got a chance, 8-month pregnancy, and I got a chance full ride to Oxford for a PhD, but I can't remain pregnant, so how am I gonna raise this kid? Perfectly good reason. You may think it's horrible, who cares what you think? If she thinks I can do this under the law, you can. But since this is not defining what health is in this particular law, it's anything you want. And the fact you have a health professional who says, you need this, I know, I'm nothing called COVID. I'm not really sure what the heck health professionals know what's reality, what should and shouldn't be done. PhDs, doctorate degrees, they mean nothing in terms of whether the person is telling you the truth. This is a open-ended thing done for pure reasons to get the vote up, in my concern. Not necessarily about getting the vote up for this, but for other things, hoping they'll vote certain ways.
Thank you. I'll come back to you, but I want to get to people that we haven't heard from yet.
Laws affect 100% of us. Therefore, the adoption and making of laws is of extreme diligence and do our homework. It is for safety, it is for the protection of society, and that's what we need to have. So let me shift gears. The big elephant in the field here is right now, you have to have an RX to get the pill, the abortion pill. It is prescription by a doctor, medical doctor. My daughter is a medical doctor. She can prescribe these things. This passage will remove having a doctor write that RX. So here's the obvious point here. There's a company who, Danco, which you can't find out about who it is, where they're at, manufactures a pill. They're out to make a ton of money in selling this to women and girls for their abortion. There is no accountability for them on this legislation. This is horrible. I understand why they would pay the money to have 8 states to be able to legalize this. They're going to make a killing on killing babies. This is not good for all public. It's not good for our safety. It's not good to be on our Constitution. This is not where we need to be as Arizonans, and I hope we don't pursue this. I hope that we pursue life. We already have abortion. You can have it. You can buy the Plan B over the counter. You can go to the doctor and have an abortion up to 15 weeks. We already have it. For them to say they can't, that's a lie. They can. It's on the books. It's AR. I looked it up. It's on the books here in Arizona. We already have it. Thank you.
Thank you.
Oh, it just piggybacks what this fine gentleman was saying, just the, and this gentleman over here, the ambiguity is of huge concern. As the opponent of Proposition 139 said, the attorney in favor of 139 has said that this measure is for before fetal viability, but also after. And please, you two, the hearing, because that's in their own words. But insofar as the ambiguity, healthcare professionals, you know, your daughter's a doctor, Joe, I know your daughter's a doctor. In no way, in shape or form, does healthcare professional indicate a medical professional. So this indicates the loose language allows for non-medical healthcare professionals to potentially perform abortions, and this measure would even allow for the protection, as clearly stated today, of anyone performing abortions, even including those that should not be. So, I agree, they're either idiots or evil or potentially both.
Thank you.
Can you just tell us who wrote the bill? Who did the proposition? Who came up with the proposition? I called over to the, you should know since you're the election office.
I'm not certain exactly who wrote the language. Are you aware, Tony?
We know what party it came from, we'd like to know who wrote the bill.
Well, there was the committee, I don't know which one the committee was that gathered the initiatives, and so they wrote it. Yes, yeah. So they wrote it.
So what committee is it?
Arizona for Abortion Access is the committee.
Okay, so then most likely there's probably maybe two Republicans and the rest Democrats, but the Rhinos and Democrats.
Well, the Secretary of State's office is a filing office, so when this initiative was filed, it's given a serial number, and in addition, the language was attached. So the Secretary of State's office had no input on what the language.
Certainly emailed me who the committee was, so it's a decision committee that put this up.
You can find that on our website, and after I navigated through, and it has all of their information, the contact email, phone number, address. So I can walk you through it.
And I think she has a question.
How do you never run? Because I believe that God moved up to create of us human beings. I do not do abortion at any time with the exception of if the mother's life is in danger. And like the gentleman said, take care that you try everything you can to save the child. The other thing that I find in this is that parents don't have to be informed. They're very nothing. What happens if something happens when that teenager is having an abortion and things go wrong? Who foots the bill to bring back this child, to save this child's life? Is it them now then? Does it go back to the parents? Or does the state, or does the physician, is he responsible? I'd like to know that. It doesn't say anything on here. Who's responsible if they mess up somebody's life?
Morgan, do you have a response in regarding to the fiscal impact?
I can comment on, my name is Morgan Garcious, I work for the Joint Legislative Budget Committee. We're a nonpartisan fiscal office for the state legislature. On our website, we do have fiscal impact statements for all of the ballot initiatives. Our fiscal analyses generally focus on the fiscal impact associated with state and local governments. So for Proposition 139 specifically, under current law, the state and local governments are prohibited from spending public monies on health insurance that cover abortion services, unless it's necessary to save the life of a woman. So that policy wouldn't change, so state or local government expenditures specifically wouldn't be impacted by this initiative. Compared with current law, the initiative could impact the number of abortions that are performed in Arizona, but we can't determine in advance how that impacts, if there would be any indirect impact on state and local governments. So that's our general statement on the fiscal impact
So what
associated.
you're saying is that the cost goes back to the givers and the taxpayers. Is that correct?
Could you help me understand what your specific question a little bit better?
Who pays for it in the end? The taxpayer, correct? Because where do you get the funds? Because it's the taxpayers.
We can speak specifically to what state and local governments are spending on, but that's a challenging question to answer without more context on public health insurance policies.
which then will be included in their health insurance plans and things like that. So that is going through the courts right now as we speak in the state of Michigan and the state of Ohio. So expect that as a guaranteed fundamental right, that will also be translated and decided in the courts here. Just as all of this vague language that's in this bill, this is all going to be decided not by your doctor and the woman, but a lot of this stuff is going to be decided by the courts. That's my comment.
My question, in the rectangular box under descriptive title, I don't see anywhere, and maybe it's just I don't see it. Somebody brought up that it doesn't have to be a medical doctor. Well, I don't see anything that says it has to be a healthcare professional that performs the abortion. According to this, it could be the 15-year-old boyfriend, and they would be protected, or am I wrong? I don't see it.
With the descriptive title, the Secretary of State was limited to 50 words, so not everything in the initiative could be contained.
So where could we read the actual initiative instead of just the 50?
The actual initiative will be provided, the full text in the publicity. Yes.
And it's also on the Secretary of State's website right now. Once you go to azsos.gov, you will click on elections and then go to ballot measures. And then from there, you'll be able to navigate to find the actual language.
And the actual language does say healthcare profession, or does it say medical?
Healthcare.
Healthcare professional.
I want to get to your question.
Actually, you got it covered.
You got it covered? Is there anyone else that would like to speak? And I'm going to get to you before we move on to Proposition 140, because I want to make sure that I provide equal amount of time to Proposition 140. And so,
Can I ask questions? I
Yes.
guess I'm confused. Okay, so with, going off of what this, a lady said here, so if it says healthcare professional, and we're still unsure about exactly what it says, does that mean a CNA could perform an abortion?
Yes.
Or a veterinarian?
Yes.
Or a medical receptionist?
There are over 25, there are only 25 classifications in the Arizona revised statutes of healthcare professional. It ranges from massage therapists to CNA,
Oh my gosh.
people who don't have the subject matter expert to do this procedure. It's extremely risky.
Okay, and then my second question is the one that I think concerns me the most, is it says here, as you mentioned, before and after fetal viability. Well, all of us mamas that have had children know that my 1-year-old is still darn dependent on me and would die if I was to walk out the house and not provide food and water and care and all that. So that really concerns me. So with that said, I know this is probably talking about the viability of a child at 9 months gestation. But explain to me why or when is too, I mean, at what point is the decision made? I mean, if a baby is born completely viable, laying on the table, crying and kicking and doing all that, that it was intended for an abortion, what do you do with that child? What happens to that baby? I really need to know this. This is important. I want to know what happens to that little tiny human that's crying and screaming that was intended to be aborted. What does the state say about that? I really need that clarified.
Valid questions. I just want to know, I'm a lawyer, and we just don't have technical expertise in healthcare.
I understand that, but if you're
Under Prop 139, if a baby was born in a botched abortion, it literally could be laying there on the stainless steel table to die with no extraordinary measures made to save the life of that baby. And I'm a visual person. This is a 26-week baby. This is a 26-week baby. And late-term abortion, which is what Prop 139 does, literally, this is a 5-pound baby. This baby would be killed under Prop 139. Why do we need Prop 139? We don't need Prop 139. Please share with everybody you know. Get the message out of what this bill truly is, all your friends and family, to help us get the word out to vote no on Prop 139, because it is not health care for women. It is not good for our women, for our sisters, for our daughters.
I must say, I really do appreciate you all coming, especially from the state. I appreciate that. I'm very, very disappointed that the opponents of this bill did not come and answer my question. And I must say, I do wish that the state could answer legislation questions that they're publishing and putting out in brochures, because it's on us now for me to make a phone call. Well, who do I call at the state to explain this more to me? I mean, I understood what you said, but I'd like to hear from the state that it tells me the state acknowledges that a 26-week little human could lay on a stainless steel table and die without any measures to care for it.
I expect that the proponents do not come because they do not want you to hear that. They do not want their lives, they don't want to be in the hot seat, and they don't want to be called out for their lives.
Joe, what organization do you use, or are you from?
I'm with Arizona Right to Life, and I'm a former state legislator.
I'm gonna come to you, I'm gonna take one more question or comment, and then we're gonna move on to Proposition 140. We're gonna have to keep it really brief, less than 30 seconds, but this gentleman, he was first, and so we're gonna go with him. And then I'm gonna have to wrap it up. I hate to cut it off, but we're gonna have to wrap it up, because I wanna make sure that each person gets one chance, at least one opportunity to speak, and so that's the purpose, and I want to provide Proposition 140 in equal amount of time as well. So I will.
Okay, he's gonna let Leah's comment speak. So the one thing I wanted to comment on is that I wanted to say to the Secretary of State that I was very disappointed in the description of the no vote on our ballot. I feel it is highly biased, because it says that this will leave in place current laws that restrict abortion before fetal viability. I feel that this no is very, very biased. It could have been written that a no vote would leave in place the current state law that allows abortion up to 15 weeks, and after that, in cases of medical emergency, including keeping the current laws in place in Arizona, including an ultrasound, as well as informed consent for the women, as well as parental consent. So I feel that Andre Plantis did a very poor job and a very biased job. And as an Arizona citizen, I am going to ask my legislators to write a law against biased stuff like this.
Yes, and this will be the last comment on Proposition 139. Yes.
Thank you. I said before, there's really only two options. The author of this is either an idiot, a committee or one, doesn't matter, or they're evil. This is the kind of ambiguity, this ambiguity that's used against us. And this young lady used a term that appeals to us as though they think we are idiots. Oh, it's qualified because we need to protect a mother where she's in danger of dying from being pregnant. That has never, ever, ever, one time been the issue. There's two living people. No, it was the comment you made. It was just an offhand comment. This is not trying to be, it is trying to be persuasive. Sorry, I'm not turning away. That's never the issue. A doctor is gonna say, there's 2 living people here.
Sir, just to clarify my comment, I was just stating what.
No, you're absolutely right. No, you're absolutely right. And this is nothing against you. Well said, nothing against you. Nothing. My point is that that is in the air, but it is utterly irrelevant. Just like the irrelevance of the trimester, just like the irrelevance of viability. Those are irrelevant terms. They're playing on us so that we can misunderstand. They're treating us like we're idiots. Thank you.
Thank you, everyone. And now we will move on to Proposition 140, Make Elections Fair, Arizona Act.
There's so much that needs to be said about it. It's just not being said.
And now for Proposition 140,
Yeah, so-
also known as the Make
No,
Elections
really.
Fair, Arizona Act. So we'll be discussing this, qualifications and disqualifications of voters. So currently, the amendment, the first section, where you see no person shall be entitled to vote at any general election unless such person is a U.S. citizen, is over 18 years or over, and has state residency. That is currently the amendment. The rights of U.S. citizens to vote, hold office, shall not be denied a bridge on account of sex. This proposition would add the political party affiliation or non-affiliation. It would also include no person shall be denied a ballot for public office, nor be restricted from selecting any candidates for public office, and also based on the person's political party affiliation or non-affiliation. And then no person who is adjudicated and an incapacitated person shall be qualified to vote, nor shall any person convicted of treason or felony be qualified to vote unless restored to civil rights, which that is currently in the amendment. The highest number of votes received and voter rate. So currently, person or persons receiving the highest number of legal votes shall be declared elected. The proposition would include, does not prohibit the use of voter rankings to determine which person or persons receive the highest number of legal votes.
Can you explain that?
Yes, so it does not prohibit the use of voter rankings to determine which person received the highest number of votes, which I'll go into it in another slide. It'll go over how it breaks down. There's 2 differences there. And then the direct primary election law. So the first section, I'll go over it. They added state, and that's why you'll see it bolded on the screen. So legislators shall enact direct primary election that provides for the nomination of candidates for all elective state and county offices and for U.S. Senator and Representative in Congress. This would add all qualified electors may vote in the primary election regardless of the qualified electors or candidate political party affiliation, and all candidates who qualify for election to an office shall be placed on the same ballot for the primary election regardless of the candidate's political party affiliation or non-affiliation. All candidates for an office, regardless of political party affiliation or non-affiliation, shall have the same signature requirements to qualify for the primary election ballot. Qualified elector may sign a candidate nomination petition without regard to political party affiliation or non-affiliation of the elector or candidate. Does not prohibit political party from endorsing or supporting a candidate. If the law allows a candidate to list the candidate's political party affiliation next to the candidate's name on the ballot must include a statement
that the political party affiliation does not indicate a candidate has been nominated or endorsed by the political party, only reflects the candidate's political party registration. And for any office, one candidate is to be elected. 2 to 5 candidates may advance from the primary election to the general election. For any office, 2 candidates are elected. 4 to 7 candidates may advance from the primary election to the general election. For any office, 3 candidates are to be elected. 6 to 8 candidates may advance from the primary election to the general election. Candidates' political party affiliation or non-affiliation cannot be considered when determining the candidates to advance from the primary election to the general election. If the legislator does not enact a law that becomes effective on or before November 1st, 2025, the Secretary of State shall determine the number of candidates for each office who may advance from the primary election to the general election. The Secretary of State shall prescribe a process if 3 or more candidates may advance from the primary election to the general election for an office to which 1 candidate will be selected, and the legislator has not prescribed a process by which voter rankings are used to determine which candidate is elected to an office at the general election. Legislation may amend the Secretary of State's determinations made, except that the legislator may not modify the Secretary's determination as the number of candidates that may advance less than 6 years after the Secretary's determination is made. Does not restrict qualified electors to change through an initiative or referendum the number of candidates who may advance from the primary election to the general election. Each candidate for offices that have primary elections may appear on the general ballot if a candidate qualifies for the general election through a primary election, fills a vacancy created by the death or withdrawal of a nominated candidate at the primary election. Not more than once every 6 years, legislator may enact legislation changing the number of candidates who may advance from the primary election to the general election. Does not restrict qualified electors to change through an initiative or referendum the number of candidates who may advance from the primary to the general election. Not subject to requirements in Article IX, Section 23, expenditures required by initiative or referendum funding source. And the general election, so 2 candidates. If 2 candidates may advance to which 1 candidate will be elected, the candidate receiving the majority votes cast is elected. 3 or more candidates. If 3 or more candidates may advance to which 1 candidate will be elected, voter ranking shall be used to determine which candidate is elected for that office. If the majority of votes cast do not rank a single candidate as the voter's first choice preference, then the procedure shall provide for the tabulation of all votes legally cast for that office and take into account voters' rankings of candidates to determine which candidate is elected. Prohibition of expenditure of public monies for political party elections. So subsection A, except as provided in subsection B, public money shall not be spent to administer political party elections, including without limitation, precinct committee officers, presidential preference election, and partisan primary elections to nominate a candidate for public office, applies to all jurisdictions in the state. Subsection B, public monies may be used to administer presidential preference elections if all persons registered as no party preference or independent, or who are registered with a political party that is not qualified for representation on the ballot may vote in the election of any one of the political parties that are qualified for the ballot. Applicable date, if approved by voters, this constitutional amendment shall apply to elections occurring after July 1st, 2026. And then the ballot language, a yes vote Proposition 140. A yes vote shall have the effect of allowing all eligible voters to vote for any primary election candidate, regardless of party affiliation, imposing the same signature requirements on all candidates for a given office who wish to appear on the primary ballot. Generally prohibiting the use of public funds for political party elections, allowing future law to determine how many candidates advance from the primary election as well as the process by candidates are elected to the general election. If future law provides that 3 or more candidates may advance to the general election for an office to which one candidate will be elected, voter rankings shall be used. A no vote for Proposition 140. A no vote shall have the effect of maintaining current requirements relating to primary and general election processes. Now we do have Patricia up, who will go ahead and speak here for us.
I'm here because some of the representatives from the Arizona Free Enterprise Club who are at other places on ballot information needed somebody to speak for them. So I have a 4 minutes, it's not really 4 minutes, but I have a statement to make. I can answer minimal questions because I wrote ballot arguments for 2 of the other props and not this one specifically. So Prop 140 is a sprawling measure that adds 15 separate amendments to our state constitution to implement California-style election schemes in Arizona, like ranked choice voting and jungle primaries, that will confuse voters, delay results, and results in voters' ballots being tossed out and not counted. Jungle primaries result in candidates from only one political party appearing on the general election ballot, disenfranchising many voters. Even worse, the drafters of this measure gave one partisan politician, the Secretary of State, the power to decide how many candidates will proceed to the general election up and down the ballot, including for his own race. Based on how many candidates the Secretary of State chooses, ranked choice voting might be required, meaning we will have a patchwork ballot with different schemes for different races, meaning some candidates will operate under one set of rules and other candidates under a different set. You might have 5 candidates to choose from for governor and rank them 1 to 5, and then for Secretary of State, you might just be 2 candidates and you vote for 1 all the way up and down the ballot. The drafters of the measure also exempted themselves from the constitutional requirement that a measure that will cost the state money must address where that money will come from. Finally, Prop 140 is opposed by Republicans, Democrats, and third parties. It's supported only by the special interests who drafted it and who wanted to count 40,000 duplicate signatures and for the courts to put it on the ballot despite the fact it does not have enough legal signatures to qualify. These schemes have been tried in California, which is no less partisan than any other state. On the contrary, they have elections where only a single party makes it to the general election ballot, and we see more manipulation and gamesmanship of the process. Arizona already has an open primary system where independents get to participate in. They just have to choose which primary, not both. Prop 140 will make it impossible for third parties to make it to the general election ballot. It will confuse voters. It will lead to long lines. The simple truth is that it was poorly drafted and tries to do much, hoping to trick voters into accepting all 15 amendments by only discussing one. Prop 140 is wrong for Arizona.
Are there any questions or comments for Prop 140?
Yes, ranked choice voting sounds very confusing to most people. And the point you made about the Secretary of State may select the number of candidates to advance from primary to general. if the legislature does not pass a law, just how would the Secretary of State make that selection? It's not stated.
Thank you for that question. That was, this is a complex initiative, I would definitely say. So for this initiative, it directs the legislature to write laws in accordance with what's here. So for example, they have to write laws about the number of signatures candidates need to gather to be on the ballot, because all candidates will be treated the same, it won't be broken down by party affiliation. However, it does give restrictions on how the legislature can handle the number of candidates that progress from the primary election to the general election. So, for example, for any one office where there's an election, the up to 2 to 5 candidates may advance to the general election from the primary. But it's up to the legislature to choose whether it's 2, 3, 4, or 5 candidates. Any more than 2 candidates advancing from the primary to the general would require ranked choice voting. So, or actually, it could be a majority, like we saw there. So, it's a requirement that the legislature write this legislation within the next year, by November 1st of 2025. In the event the legislature fails to do so, then it's the requirement of the Secretary of State to write the laws.
With no criteria for how the Secretary of State does
The
it.
Secretary of State has to work within those criteria. So for a candidate that's elected to one office, so like the statewide offices, the law, this initiative would require, assuming if the voters pass it, it would require that the legislature write that either 2, 3, or 4, or 5 candidates then move on to the general election. So there's a lot of leeway. For an office with 2 candidates to be elected, so for Arizona House of Representatives, there could be a minimum of 4 people that advance from the primary election to the general, up to 7 candidates that advance from the primary to the general. And then for 3 candidates to be elected to an office such as Corporation Commission, there have to be at least 6 that move on to the general election, up to 8 candidates that advance from the primary to the general election. So those are the parameters within which the legislature must work, and they have 1 year to pass laws accordingly. And as Adriana did so well, she explained that the law will go into effect for elections after July 1st, 2026.
Question? On the primary ballot, does it have a designation that are Republican and Independent names?
It could. It can.
Could the legislature say we have to do that if we're running from a party? Or can the person view of the legislature say no, he has to have a party affiliation?
They can have their party affiliation listed, but it doesn't, there has to
So
be.
the candidate decides whether they get a D or an I beside
It's whatever the candidate's party affiliation is, the candidate will be able to choose that.
And then the Democratic Party or Republican Party, it has to say somewhere that the fact that I put a D or an R behind my name doesn't mean that the D or the R supports. Correct.
The party can say,
Is not endorsed.
is not endorsed by us?
Yeah, or they just, no, it says that doesn't mean that I am supported by the Democrats or Republicans just because I put a D and an R.
That's not written down anymore.
No, that's it.
Yeah, it has to be there.
That will be in there.
But on the ballot, will say that?
Yes.
On this ballot? I mean, when we're voting, when people go to vote.
Oh, no, for this election.
Yeah. And
No, well, it's in the language
People
of
don't know, in
the-
other words, people won't know that that's what they're voting for.
So it's the person's indication on the ballot, the candidate, as far as what mean that the political party necessarily endorses that person.
What group wrote this one? And did they just decide that politics was too easy to understand, so they have to make it a little more difficult?
I do not know the name of the initiative was submitted by Make Elections Fair.
Oh, okay.
Yes.
Okay, my concern here is you've explained all this stuff, and if I hadn't been here and I walked into the ballot box, I'd have no idea what was going on, what it really meant. I need a court person, good intelligence, who can explain the name of this. He's Agent K from Men in Black. He's sitting on the bench, and Will Smith's character says, people are smart, you can tell about this stuff. He says, a person's smart. People are dumb, panicky, dangerous animals, and you know it. This is the fact of the American population. The populace doesn't even know what happens on the ballots. And this one is nothing but confusion, which is why it was written this way, because example is a perfect example. And we're trying to party on this example. According to polling, in the 4 top major issues, Trump is ahead. But if you simply say to the same people, apparently, who would you vote for? You're going to vote for Harris. My brain is ready to explode when the 4 most important things that you should vote for, they still in it. Because people are stupid and therefore dangerous. And so, does anybody know if making changes in the Constitution by the general vote of the public, is that in the original Constitution for the state, or is that voted in by someone?
No, that was part of the original Constitution. Article 4, Section 1 is the right of the people to legislate directly.
Well, all of these propositions are voted yes or no based on the people's vote. It's just that the two we've discussed today came forward from the people. The other ones came forward from the legislature.
Yeah.
But we always vote.
But the thing is, general voting, that's why we are not a democracy in the United States. We represent a republic. Because these guys are smart people. They didn't have PhDs and stuff, but they knew the best, the worst form of government is a democracy. Because they're the same people that executed Socrates, because they're a Democrat. So,
How do you publicize this forum today? Because I just happened to someone told me. How are we supposed to know that this was happening? Because we didn't have a real good deterrent.
We publicized it through our social media.
Oh, well, there you go.
Yeah, honestly, I only knew about it because I'm very pro-life, and I knew about it because of Prop 139. And I didn't know what was happening. I think it's wonderful, by the way, thank you.
Yeah,
And this is a really good
And it's
point.
also on our website as well.
Okay, so people who are concerned or care, and want to know more, because I really appreciate this whole packet, because I can go home and like read through it. Yeah, this is great, and I don't know if there's a better way to publicize it, aside from a couple of controversial topics, because a lot of these ballot measures that go back into legislation and how it's in law, I don't think people care, and I think like, yeah, we should care. A real quick comment, everything, like when I read through this, and I read a couple things of, whoa, everything you said vindicated my gut on this, and all I need to know is I don't want to do what California's doing. It's in Arizona, so, yeah, I appreciate
Right
that.
now, I believe it is going to be on the ballot, but it's up in the air whether the votes on it will count because of the signature issue.
Oh, okay.
It went to court, Arizona Free Enterprise took to court about the signatures that were on there. Initially, they said 40,000. It was reviewed by special master, I think they called it. 38,000 are duplicates.
Oh.
Even with that, they're short, I believe the number was 3,300 to qualify for the ballot. So it's going back again to the Supreme Court, from what I understand, because the judge who decided thinks that the percentages of how they, can you explain that part of it?
Well, is it the correct, like, there's a certain percentage?
There's an algorithm to how they figure out how many signatures must qualify.
Yes,
Right.
yeah,
So 15%.
Right.
yeah,
Okay.
right,
And
yeah, I
so
read about that earlier.
he has an issue with that, so I believe, once again, it's going back to the Supreme Court to make it state
Yeah.
Supreme Court. to
And I
make it
guess what
state.
frustrates me is that if legislation is poorly worded, and I do think that, I wish that the language that goes on the ballot was a little more clear, but I think it's frustrating because it's such a waste of taxpayer dollars. Because, It has to go through, the laws and the courts and.
Alaska did this,
Waste of time.
and they are putting up a proposition to go back to the way it was.
And I just have one question, from the Secretary of State standpoint. I know we get, and I will be looking through my ballot, the voter information pack. I do believe, and correct me if I'm wrong, they do tell you which organizations back, which ballot measures, so that we can kind of get an idea of the funding, that kind of, the special interest.
Well, within the publicity pamphlet, of course, it will, provide you with the title and text of all the measures, whether they're the citizen initiatives that are being proposed or the legislative referrals. There's also arguments, within the pamphlet, for and against. And some of those arguments are sponsored by different organizations.
Okay, thank
And
you.
that information will be.
That actually helps too, when you see what who's behind this. Yeah, exactly, thank you.
Are there any other comments or questions?
So one clarification on, so, primary, so, they'll have primary, that's the third person, who they are support, and the DB side, and I can DB side my name, okay? So, does the person understand that by this law, that I'm not necessarily wanted by the Democratic Party?
Yeah.
But I just feel like that's why I said
registry.
I'm registered, that's all, just a registered Democrat. So I could be something else, libertarian, and sign up as a Democrat, and they wouldn't know, but I tell them, because I now registered, the DB side makes me a Democrat. So it splits the Democratic vote. This is how, this is the dangerous thing. You can have 5 people put DB side name, or Republicans by the same, and split the vote. And then it forces you to rank voting. You basically put your hand on the scale of the election.
Exactly.
This is the worst thing for democracy.
Yeah. That's my biggest opposition to it, yeah.
But you never know that when it comes.
Any other questions or comments? Okay, before you leave, I want to give you some important reminders for the general election. If you're not registered to vote, please do so by October 7th, 2024 at 11:59 p.m. Of course, you can register at Sanders, Arizona, online, or you can fill out a paper form and mail it in to your county recorder's office. In-person early voting begins October 9th, 2024, and it goes through November 1st, 2024 at 7 p.m. Of course, we have election day on November 5th, 2024, and polls are open at 6 a.m. and they close at 7 p.m. I would like to thank you all for coming out today. Again, we really appreciate you providing your public comments, asking your questions, because we are definitely here for you. And of course, feel free to visit our website at www.azsos.gov, or even go to arizona.vote to get more information regarding the ballot measures, all of the measures that will be on the ballot. Of course, the publicity pamphlets will be coming soon in the mail, but we actually have it posted on our website now, so if you have any free time, feel free to go over to our website and look at it, or just wait for your copy to come in the mail. Thank you again, and have a wonderful day.
Thank you so much. See on November 5th, if there are people in line at 7 o'clock.
As long as you're in line at 7 o'clock, you can go in and vote.
And that is the national, everybody, or is it a statewide policy?
That's stated.
So each state can determine different.
Are you talking about the time?
Yeah.